Hello and welcome to the next training in our No Surprises Act training series for the Center for Consumer Information and Insurance Oversight. My name is Judah Katz, and I work in the Compliance and Enforcement Division within the Oversight Group, and I'm joined today by Raisha Conway. We will be presenting today on the No Surprises Act's continuity of care provisions, provider directory requirements, and public disclosure requirements. Our agenda for today includes providing a background on the No Surprises Act training series and where we're holding within that. We'll discuss continuity of care requirements, provider directory requirements, public disclosure requirements, and provide a website, a web address where people can send questions on any of the topics discussed today. First, we'll go through some initial legal disclaimers. As always, the information provided in this presentation is intended only to be a general informal summary of technical legal standards. It is not intended to take the place of the statutes, regulations, or formal policy guidance upon which it is based. This presentation summarizes current policy and operations as of the date it was presented. We encourage readers to refer to the applicable statutes, regulations, and other interpretive materials for complete and current information. The contents of this document do not have the force and effect of law and are not meant to bind the public in any way unless specifically incorporated into a contract. This document is intended only to provide clarity to the public regarding existing requirements under the law. This communication was printed, published, or produced and disseminated at U.S. taxpayer expense. And now we'll start with some of the background just on our training series for the No Surprises Act. The overview, I guess, of the No Surprises Act first. The No Surprises Act introduced new requirements for providers, facilities, and providers of air ambulance services to protect individuals from surprise medical bills. These requirements, first, prohibit providers and facilities from directly billing individuals for the difference between the amount they charge and the amount that the individual's plan or coverage will pay, plus the individual's cost-sharing amounts, such as balance billing, in certain circumstances. Second, the No Surprises Act requires providers and facilities to provide good faith estimates of charges for care to uninsured or self-pay individuals upon scheduling care or on request, and for individuals with certain types of coverage to submit good faith estimates to the individual's plan or issuer. Third, to create a patient-provider dispute resolution process for uninsured or self-pay individuals to contest charges that are substantially in excess of the good faith estimate. Next, to require certain providers and facilities to publicly disclose restrictions on balance billing. And finally, limit billed amounts in situations where a provider's network status changes mid-treatment or individuals act on inaccurate provider directory information. On slide 7, we go through the scope of individuals that are protected under the No Surprises Act. Beginning on January 1st, 2022, these No Surprises Act requirements will apply to items and services provided to most individuals enrolled in private or commercial health coverage, such as employment-based group health plans, both self-insured and fully insured, individual or group health coverage on or outside the federal or state-based exchanges, federal employee health benefit plans, FEHB plans, non-federal governmental plans sponsored by state and local employers, certain church plans with an IRS jurisdiction, and student health insurance coverage as defined by 45 CFR 147.145. Some requirements also apply to providers and facilities with respect to uninsured or self-pay individuals, like requirements that providers and facilities provide good faith estimates for scheduled care or upon request. Requirements under the No Surprises Act don't apply to beneficiaries or enrollees in Medicare, Medicaid, Indian Health Services, Veteran Affairs Health Coverage, or TRICARE. These programs have other protections against high medical bills. The protections also don't apply to short-term limited duration insurance, accepted benefits, or retiree-only plans, or account-based group health plans. And on slide 9, you'll see a series of trainings with a chart describing which trainings and the relevant statutory and regulatory citations. And for this training today, we'll be going through the public disclosure of individual protections against balance billing, restrictions on how much providers can bill, and then you'll see the third one that's also highlighted with an asterisk next to it. Next slide, please. And with this, I'll turn it over to Raisha.
Thank you, Judah. I am Raisha Conway with CMS, and I work for the Center for Consumer Information and Insurance Oversight, Compliance and Enforcement Division. And I will be going over continuity of care requirements. So, overview of the No Surprises Act's continuity of care requirements. In general, if a provider or facility ceases to be an in-network provider because of a termination of a contract, certain continuity of care protections apply to an individual who meets the definition of a continuing care patient and is furnished items or services by such provider or facility for which the individual's plan or issuer provides coverage. For the continuing care patient whose providers or facilities contract termination leads to a change in network status, the plan or issuer must timely notify each individual enrolled who is a continuing care patient of the termination and their right to elect continued transitional care from the provider or facility. Provide each individual enrolled who is a continuing care patient an opportunity to notify the plan or issuer of the need for transitional care, and permit the continuing care patient to elect to continue to have the same benefits provided under the same terms and conditions as would have applied under the plan or coverage had the termination not occurred, with respect to the course of treatment furnished by the provider or facility. So continuing the overview of the No Surprises Act continuity of care requirements. The election may last until the earlier of 90 days, starting on the date their plan or issuer notifies them of the change in network status, or the date on which such individual is no longer a continuing care patient with the provider or facility. In this situation, the No Surprises Act requires that a continuing care patient's treating provider or healthcare facility must accept payment from the plan or issuer and cost sharing from the individual for items and services as payment in full, or continue to adhere to all policies, procedures, and quality standards imposed by the plan or issuer for an individual as if the termination hadn't occurred. We will review what each of these terms mean throughout the presentation. Note, the departments anticipate issuing future rulemaking implementing requirements for this No Surprises Act provision. On slide 13, the scope of providers and facilities that must comply with the No Surprises Act continuity of care requirements. The No Surprises Act continuity of care requirements apply to healthcare providers and healthcare facilities. The statute doesn't exempt any categories of providers or facilities from this requirement. So note, the departments anticipate issuing future rulemaking implementing requirements for this No Surprises Act provision. And on the next slide, scope of individuals considered continuing care patients. Continuing care patients are defined as individuals who, with respect to a provider or facility, are at least one of the following. 1, undergoing treatment from the provider or facility for a serious and complex condition defined as A, in the case of an acute illness, a condition that is serious enough to require specialized medical treatment to avoid the reasonable possibility of death or permanent harm. B, in the case of a chronic illness or condition, a condition that is 1, life-threatening, degenerative, potentially disabling, or congenital, and 2, requires specialized medical care over a prolonged period of time. Continuing the scope of individuals considered continuing care patients. 2, undergoing a course of institutional or inpatient care from the provider or facility. 3, scheduled to undergo non-elective surgery from the provider or facility, including receipt of post-operative care from such provider or facility with respect to such a surgery. 4, pregnant and undergoing treatment for pregnancy from the provider or facility. 5, terminally ill and receiving treatment for such illness from the provider or facility. Again, note, the departments anticipate issuing rulemaking implementing requirements for this No Surprises Act provision. Now we're on slide 15. When continuing care patients are eligible for continuity of care protections under the No Surprises Act. Protections apply for continuing care patients who are receiving covered services or items from a treating provider or healthcare facility, and their treating provider or healthcare facility experiences a change in network status due to one of the following. The provider or healthcare facility's contractual relationship with the individual's plan or issuer is terminated. The provider or healthcare facility's terms of participation in the plan or coverage change, resulting in a termination of benefits with respect to the provider or healthcare facility. A group health plan's contract with a health insurance issuer offering health insurance coverage in connection with the plan is terminated, resulting in a loss of benefits provided under such plan with respect to the provider or healthcare facility. Slide 17, continuing the care patients are eligible for continuity of care protections under the No Surprises Act. So terminated is defined as, with respect to a contract, the expiration or non-renewal of the contract, but does not include a termination of the contract for failure to meet applicable quality standards or for fraud. And here's the note again. The departments anticipate issuing future rulemaking implementing requirements for this No Surprises Act provision. So now we come to a knowledge check. Joan is a 30-year-old female who is insured through her employer. She is 30 weeks pregnant and following up with her obstetrician regularly. At her next visit, Joan is told that her obstetrician no longer maintains a contract with her insurer due to the obstetrician voluntarily not renewing her contract. Would continuity of care protections apply to Joan with respect to her obstetrician? And the answer is yes. Continuity of care protections would apply to Joan with respect to the obstetrician, as the contract between the obstetrician and the plan was terminated for reasons other than failure to meet applicable quality standards or for fraud. In scenarios where a contract is terminated due to failure to meet quality standards or fraud, continuity of care protections wouldn't apply. In this example, Joan meets the standard for a continuing care patient since she is pregnant and undergoing treatment for pregnancy from the obstetrician. As a result, she is eligible for continuity of care protections because she is receiving covered services from a treating provider who has since been terminated from her plan's network. And slide 20, effective date of continuity of care requirements. The No Surprises Act continuity of care protections apply to services furnished in plan years beginning on or after January 1, 2022. Rulemaking implementing this provision of the No Surprises Act won't be published until after January 1, 2022. Any rulemaking to implement continuity of care requirements will include a prospective applicability date that provides plans, issuers, providers, and facilities with a reasonable amount of time to comply with new requirements. Providers and facilities are expected to implement the requirements using a good faith, reasonable interpretation of the statute prior to issuance of rulemaking. And now we move on to provider directory requirements. Slide 22. Overview of the No Surprises Act provider directory requirements. Under the No Surprises Act, providers and healthcare facilities must generally refund enrollees amounts paid in excess of in-network cost-sharing amounts with interest if the enrollee has inadvertently received out-of-network care due to inaccurate provider directory information. The provider or facility billed the enrollee for an amount in excess of in-network cost-sharing amounts, and the enrollee paid the bill, or maintain business processes to submit provider directory information at specified times to support plans and issuers and maintain an accurate, up-to-date provider directories. Continuing the overview of the No Surprises Act provider directory requirements. A provider is permitted to require, as part of the terms of a contract or contract termination with a plan or issuer, that the plan or issuer remove the provider from the directory at the time of termination of contract and bear financial responsibility for providing inaccurate network status information to an enrollee as applicable. So please note, departments anticipate issuing future rulemaking implementing requirements for this No Surprises Act provision. So slide 24, scope of providers and facilities that must comply with the No Surprises Act provider directory requirements. The No Surprises Act provider directory requirements apply to healthcare providers and healthcare facilities. The statute doesn't exempt any categories of providers or facilities from this requirement. So we have our note again. The departments anticipate issuing future rulemaking implementing requirements for this No Surprises Act provision. So on this next slide, provider business processes to support accurate directory information. At a minimum, providers and healthcare facilities must submit provider directory information to a plan or issuer. When the provider or healthcare facility begins a network agreement with a plan or issuer with respect to certain coverage. When the provider or healthcare facility terminates a network agreement with a plan or issuer with respect to certain coverage. When there are material changes to the content of provider directory information of the provider or healthcare facility. At any other time, including upon the request of plan or issuer, determined appropriate by the provider, healthcare facility, or the Secretary of Health and Human Services, also known as HHS. So continuing the provider business processes, providers and healthcare facilities are required to have business processes in place to ensure timely provision of provider directory information to plans or issuers no later than January 1, 2022. Rulemaking to implement this requirement will not take place until after January 1st, 2022. In the meantime, providers may have to work with health plans or issuers to make good faith efforts when these circumstances are reported. So note, the departments anticipate issuing future rulemaking implementing requirements for this No Surprises Act provision. Provider directory information that providers and facilities must share. Information that providers and healthcare facilities provide to a plan provider directory must include names, addresses, specialty, telephone numbers, and digital contact information of individual healthcare providers, and names, addresses, telephone numbers, and digital contact information of each medical group, clinic, or healthcare facility contracted to participate in any of the networks of the group health plan or health insurance coverage involved. And the department anticipate issuing future rulemaking implementing requirements for this No Surprises Act provision, which you will see on additional slides. So now we come to another knowledge check. A pulmonologist recently began a network agreement with a new health plan. Is the pulmonologist required to submit provider directory information to the plan? And the answer is yes. Under the No Surprises Act, the pulmonologist is required to submit provider directory information, such as the provider's name and addresses, specialty, telephone numbers, and digital contact information, to a plan or issuer when they begin a network agreement with a plan or issuer with respect to certain coverage. There are also additional circumstances when a provider must submit provider directory information to a plan or issuer. On slide 30, cost sharing limits for services provided based on incorrect provider directory information. Under the No Surprises Act, if an individual relies on incorrect provider directory information and as a result receives items or services from an out-of-network provider or out-of-network healthcare facility, one, their plan or issuer must limit cost sharing to in-network terms that would apply had items or services been furnished by an in-network provider, or apply the deductible or out-of-pocket maximums as if the provider or healthcare facility were in network. Two, their provider or healthcare facility must not bill an individual more than their in-network cost sharing. And again, we anticipate issuing future rulemaking implementing requirements for this No Surprises Act provision. Next slide, provider requirements for refunded individuals. If one, an individual relies on incorrect provider directory information. Two, the provider submits a bill to the individual that is more than the in-network cost sharing amount. And three, the individual pays the bill. The provider must reimburse the individual for the full amount paid by the individual in excess of the in-network cost sharing amount. Interest. The interest rate will be determined by the Secretary of HHS through rulemaking. So provider requirements for refunded individuals continue. This requirement applies to items or services furnished based on incorrect provider directory information in plan years beginning on or after January 1st, 2022. Rulemaking to implement this requirement will not take place until after January 1st, 2022. In the meantime, providers may have to work with health plans or issuers to make good faith efforts when these circumstances are reported. And the departments anticipate issuing future rulemaking implementing requirements for this No Surprises Act provision. And now we come to another knowledge check. A cardiologist has recently terminated their practice's contract with a health plan. The cardiologist asks that the plan remove the practice from the directory as part of the terms of contract termination. Is the cardiologist permitted to ask the plan to remove their name from the directory upon contract termination? And that answer is yes. Under the No Surprises Act, the cardiologist is permitted to require in the terms of a contract or contract termination that a plan or issuer remove the provider's name from the directory at the time of termination of contract. Additionally, the cardiologist is contractually permitted to require that the plan or issuer bear financial responsibility for providing inaccurate network status information to an enrollee. And now I will turn it over to Judah to finish the remaining slides in the presentation.
Thank you so much, Aisha. Now we'll discuss the public disclosure requirements. Beginning on slide 36, we'll do a quick overview of the required disclosures. The No Surprises Act requires healthcare providers and healthcare facilities to publicly share written disclosures distributed through multiple methods outlining key protections. These disclosures must include information on, number one, the prohibitions on balance billing for emergency or non-emergency services with which the provider or healthcare facility must comply. Two, any state laws governing balance billing with which the provider or healthcare facility must comply. And three, contact information for state and or federal agencies that an individual can contact to report a suspected provider or healthcare facility violation of the balance billing protections in the No Surprises Act or state laws governing surprise medical bills. These disclosures are intended to help give individuals a clear understanding of their protections under the balance billing provisions of the No Surprises Act and who to contact if they believe those protections have been violated. These disclosure requirements do not apply to providers of air ambulance services. However, HHS strongly encourages air ambulance providers to also make disclosures available to individuals. On slide 38, we discuss the scope of providers that must comply with the No Surprises Act public disclosure requirements. The following types of providers must comply with the No Surprises Act public disclosure requirements: physicians and other healthcare providers acting within the scope of their practice under applicable state law, such as a certified nurse practitioner or physician assistant, but does not include a provider of air ambulance services. Providers are not required to make the disclosures if the provider does not furnish services or items at a healthcare facility or in connection with visits at healthcare facilities, and to individuals to whom the provider furnishes items or services if such items or services are not furnished at a healthcare facility or in connection with a visit at a healthcare facility. On slide 39, we describe the scope of facilities that must comply with the No Surprises Act public disclosure requirements. The following types of healthcare facilities must comply with the public disclosure requirements: hospitals, including critical access hospitals, hospital outpatient departments, ambulatory surgical centers, emergency departments of hospitals, and independent freestanding emergency departments. On slide 40, we discuss the required methods of disclosure. Under the No Surprises Act, providers and healthcare facilities must share required disclosure information through three methods. Number one, public signage posted prominently at the provider or facility's location, for example, in a central location where individuals check in, pay bills, and so on. Number two, posting on a public, easily accessible website without any requirements for account sign-up, passwords, or paywalls. And number three, a one-page notice provided directly to individuals enrolled in group health plan or group or individual health insurance coverage that must be delivered in person or by email or mail based on the individual's preference. We will review each method on the following slides. On slide 41, the requirements for use of public signage. Providers in healthcare facilities must publicly display disclosure information on a sign posted in a prominent location. This should be a central location, like where individuals schedule care, check in for appointments, or pay bills. On slide 42, we discuss the requirements for posting on a public website. Providers in healthcare facilities must post the required disclosure or a link to the disclosure on a searchable homepage of their public website. The website should be free of charge, and visitors should not have to do any of the following to access this website: establish a user account, password, or other credentials, accept any terms or conditions, or submit any personal identifying information like name or email address. On slide 43, we describe the requirements for the one-page notice. Providers in healthcare facilities must provide a written notice to individuals with a group health plan or group or individual health insurance coverage, as well as federal employees' health benefits plans. This notice should be provided in person, by mail, or by email as chosen by the individual. The notice should be limited to one double-sided page and must use a font size of 12 points or larger. Providers in healthcare facilities must provide individuals with one-page notice no later than the date and time when they request payment from the individual. This includes requests for co-payments or co-insurance made at the time of visit. If payment isn't requested from an individual, providers in healthcare facilities must provide the disclosure notice no later than the date a claim is submitted for payment to a health plan or issuer. On slide 44, we describe the key exceptions to the disclosure requirements. Providers that never furnish items or services at a healthcare facility or in connection with visits to a healthcare facility do not need to fulfill the No Surprises Act disclosure requirements. Providers are only required to share No Surprises Act disclosures with individuals to whom they furnish services or items, and only in the situations where the services they provide are furnished at a healthcare facility or provided in connection with a visit to a healthcare facility. If a provider or healthcare facility does not have a publicly accessible location, they are not required to publicly display the disclosure content via signage. If the provider or healthcare facility does not have a website, they are not required to share the disclosure content on a public website. On slide 45, we have a knowledge check. A gastroenterologist provides services at a local ambulatory surgical center 3 days per week. The gastroenterologist maintains a public website for their practice. Is the gastroenterologist required to share disclosure information on their public website? And on slide 46 is our answer. Yes, a provider who furnishes items or services at a healthcare facility, the gastroenterologist is required to share disclosure information on their public website. Under the No Surprises Act, providers in healthcare facilities must post the required disclosure or a link to the disclosure on a searchable homepage of their public website. A provider isn't required to share disclosure information if they do not furnish items or services at a healthcare facility or in connection with visits at healthcare facilities. Additionally, a provider isn't required to share disclosure information to individuals to whom the provider furnishes items or services if such items or services are not furnished at a healthcare facility or in connection with a visit at a healthcare facility. On slide 47 is an example of the model disclosure notices. HHS has issued a model disclosure notice that providers and healthcare facilities can choose to, but are not required to use. This model disclosure notice was published as part of CMS form number 10780 and is available for download at a hyperlink through this slide deck. HHS has also encouraged states to develop model language to assist providers and healthcare facilities in meeting disclosure requirements related to the No Surprises Act. In slide 48, we describe the language accessibility requirements. All disclosures must use clear and understandable language. Providers and healthcare facilities are encouraged to use plain language in their disclosure notices and test the notice for clarity and usability when possible. Providers can find plain language accessibility and language access resources at www.plainlanguage.gov/guidelines. Healthcare facilities must make reasonable efforts to ensure meaningful access to individuals with a limited English proficiency, which may include offering language assistance services like translation of written content into languages other than English. Healthcare facilities that receive federal financial assistance must also comply with federal civil rights laws that prohibit discrimination, including Section 1557 of the Affordable Care Act, Title VI of the Civil Rights Act of 1964, and Section 504 of the Rehabilitation Act of 1973. On slide 49, we describe the special rule to prevent duplicate provision of the disclosures. Providers in healthcare facilities can enter into written agreements stating that the healthcare facility is responsible for providing the one-page disclosure to individuals on behalf of both the healthcare facility and the provider in situations where the provider delivers care at the facility. This single disclosure would need to outline restrictions on balance billing that apply to both the healthcare facility and to the provider. If a written agreement is in place and a healthcare facility fails to provide full timely disclosure information, then only the facility would be considered in violation of the No Surprises Act. Providers with these agreements should still monitor a healthcare facility's adherence to the disclosure requirements and notify the applicable state authority or HHS if there is a question of noncompliance. On slide 50, we begin our main takeaways from this presentation. First, the No Surprises Act protects continuing care patients in circumstances where their treating providers or healthcare facilities plan network status changes, allowing a 90-day transitional care period. During this time, health plans and issuers must limit cost sharing to in-network terms. Treating providers and facilities must accept cost sharing and payment from plans and issuers as payment in full. Next, the No Surprises Act protects individuals who inadvertently seek care from an out-of-network provider or healthcare facility after relying on inaccurate provider directory information. In these circumstances, the health plan or issuer must limit cost sharing to in-network terms, and the provider or healthcare facility must refund enrollees amounts paid in excess of in-network cost-sharing amounts with interest if the provider or facility billed the enrollee for an amount in excess of in-network cost-sharing amounts and the enrollee paid the bill. Third, the No Surprises Act requires that providers and healthcare facilities publicly share written disclosures distributed through multiple methods outlining No Surprises Act key protections. Note well here, the departments anticipate issuing future rulemaking implementing requirements related to continuity of care requirements and provider directory requirements. If you have any questions regarding any of the items described in this presentation or other presentations, you should please feel free to send those questions to the provider enforcement mailbox, which is provider_enforcement@cms.hhs.gov. The remainder of the slide presentation is the glossary, and we invite people to use the glossary to understand better the terminology used. And at this point, that is all we have for the presentation today. Thank you for your attention and have a good day.